Hey, what's up, everybody? Jimmy Smith back again. This time, not alone. That's right. You loved it last time. Patrick Donahue, uh, defense attorney here in South Florida, also a Carlson Gracie brown belt. We train all the time. We're good friends. Some news about Cain Velasquez. Anytime there's Cain Velasquez news, and by the way, it's Patrick who sent me this article last night. I was like, dude. And I said, well, you got to come on and talk about it. So that's where we are. Anyway, so Pat, let's get into it. The article is from San Jose. Mercury News is a newspaper up there. It's about the family. It's about the victims themselves, what they've been through. Their business got firebombed. They had to move. They are saying that they have video evidence that their son wasn't there when this alleged molestation took place. They have video evidence that he wasn't there. My listeners couldn't care less. What they want to know is how this affects Cain Velasquez. The first thing that occurred to me is, does the guilt or innocence of the son have anything to do with this? There were a few things about the sentencing that are in there, but the first thing that jumped out to me is you said in the trial, the judge can say the relevance of the molestation can be eliminated. It's irrelevant.
Right.
Don't have to talk about it at all. What about the sentencing part when motive becomes an issue? What can happen there?
Right. And that's why this article is so interesting because it really shed a light on a point of view that I didn't have yet.
Yep.
I assumed, it's innocent until proven guilty, but this whole time, the facts that I've seen so far, I made an assumption about what was going on with I think his name is Duarte. What is it?
Yep.
Golarte.
Golarte, yeah.
His case. So there's three cases going on simultaneously. So let's just, back up just so I can explain what's going on. So there is the case against Cain, criminal. There's the case against Golarte, criminal. And then there's a civil case, Cain suing Golarte and the daycare. Okay. So Cain's case, he pled guilty. We now have sentencing set theoretically for next week. It's already been pushed back numerous times. And to answer your question, the Golarte case has been pending this entire time and is now set for trial in May. I think best case scenario, even though it shouldn't affect the sentencing, Cain would have liked to gone into his sentencing saying, I shot at a convicted, child molester, as opposed to, well, his case is still pending, and now I shot at, three people who are potential victims. And these three potential victims, like they went on the news and they're talking about it. It's not good. Like you said. So the three potential victims, which are the people who are being sued civilly, and also who are, Guarte, who has the criminal case pending. So their side of the story is, and of course, there's always two sides of a story.
Right.
Whether it's true or not, the court's going to decide. But their side of the story is there is one event that this person's being charged with, and he's only facing up to 8 years. One event, one instance. And on that instance, they have video footage that he wasn't in the house. They said they have some type of alibi witness, as well as they're attacking the credibility of a 4-year-old, which is terrible.
Yeah.
But,
Yeah,
defense attorney, has
by the way,
to.
we both have one of those.
Exactly.
Yeah.
Um, but the point is that they didn't roll over and say, yes, we did this. I'm going to take my sentence. I'm pleading guilty. They're putting on a defense. So now Cain's sentencing, this news article gave us a preview of what the sentencing is going to be like. This is why it blew my mind, because they basically told us what their argument's going to be. And the mom's going to get on the stand and say that I was a daycare owner for 40 years. I had no instances of any issues. And now I had to close my daycare because somebody came to our house with a Molotov cocktail and threw it in our daycare.
Yeah, they tried to firebomb the business. Yeah.
Yep. Dad's going to come and testify and say, I can't use my hand anymore. And, the other person, I assume the person Golarte, I assume he's not going to testify anything, right? Because he's got a criminal case pending. But the point is, I think we need to look at this two different ways. And I do have more information because this is what do you think Cain's sentence would be, should be? You know, you're the judge, and of course, these things shouldn't be taken into account, but Cain shot at somebody who was accused of a crime. Let's say he didn't commit it, okay? What should Cain's sentence be as opposed to Cain shot at somebody who did commit it, right? Because we've all looked at this case this whole time and said, "Hey, this guy did this. This guy did this." And I'm going to give you another piece of evidence, that I think makes it more likely than not that I he might be found guilty. However, what if, what if these people's lives and business were irreparably damaged and he didn't do it? Wow, I mean, it's hard to consider.
Was that why this was getting pushed back over and over and over? Was Kane's defense team trying to link essentially the trial of the son and the sentencing of Cain to maybe happen at the same time? Some evidence comes out, maybe he's done this over and over, and that's not supposed to be a factor, but we live in a world where it is. It's just going
Right.
to be. Was that maybe the strategy in pushing back the sentencing?
I think possibly, I think that it definitely makes sense. Also, I think that they wanted, so in the civil case, which is super interesting, if the son takes the stand in the civil case and his criminal case is still pending, then he gets to plead the
No.
fifth, right? And then the jury, it depends on the state, but the jury gets to make an adverse inference, basically saying, well, that guy took the stand and said that he can't talk about it because he could be criminally prosecuted. Then he did it civilly. It's almost as if OJ, and again, everybody knows OJ. Imagine if the civil case came first. I know that, it was, of course, decided against OJ in the civil case. But basically, OJ would take the stand and say, I can't talk about this case. And the jury would assume, okay, well, if he can't talk about it, then he
He
did it.
must have done it.
Uh,
Right. Yeah.
there's an adverse interest in civil law, inference in civil law that doesn't come into play in criminal law. So I think that they wanted Goularte's criminal case to come first. He gets convicted, then they get him civilly, or they get him civilly beforehand, and then Cain's sentencing. And instead, now we have Cain going first. So, I do not know what's going to happen.
Another thing in the article that I found even more interesting, and please, I need your help in this one. I need the education here. Jiu-jitsu, I teach you. Law, you teach me. Except you beat me up less in law. It's weird. But here's the deal: is the article said that the prosecution's first attempt at sentencing, whatever you want to call it, to the judge appeal was decades. And
Yeah.
Kane's team went, no, we're going to, they tried to fight back against that. From what, as a layman, I think once you plead no contest, aren't you throwing yourself at the mercy of the court? Can't they give you whatever
Yes.
they want? So, how much leeway does Kane's defense team have to go, that's too much? If you keep doing this, we're going to, change our plea? Is that a
Right.
possibility? What's going on here?
So something that's always haunts me, one of my first trials that I ever did, it was like this DUI case with this resisting without violence. And long story short, it was my first ever trial and I beat the DUI, but we lost on the resisting. And I went up in sentencing and I was pompous. It was my first trial. I was like, oh, the state's requesting this, but we won the DUI. So why would he have to have that? That's too much. And the judge basically slammed me because it's at the end of the day, you can have a great position and scoff at the sentencing recommendation, but the judge decides. So if the state is asking for decades in prison and they're saying, no, that's absolutely unacceptable, hopefully it's a fake it till you make it. And the judge is like, yeah, that's absolutely unacceptable. But that could go the other way. It's gone the other way for me. I think that, it's a terrible war story to share, but the point is, you never know.
Does his defense team have any leeway to withdraw the no contest plea and say, okay, fine, we're changing to not guilty and we're going to court? What can they do? My question is, once again, no contest means I'm at the mercy of the court.
Right.
Can the defense team go, okay, if you keep asking for life or 30 years or whatever it is, fine, we're not going to plead no contest. We're going to go to court and roll the dice. Is that even an option at this point?
There's mechanisms to do things like that, but generally that's like an ineffective assistance of counsel where you're blaming that your attorney didn't explain the sentencing guidelines.
You
So
need
you
a way
want to,
out to wiggle out of it.
right.
Right.
So I think they're locked in. I think they're moving forward. I think that they are going to put on good sentencing evidence, and I'm really hoping that his sentence is mitigated to something that doesn't involve decades in prison.
Now, this is where, as you pointed out so effectively in our first interview, the judge can say, had it gone to trial, his motivations aren't that relevant. And what I mean by
Relevant.
that is, and people have trouble understanding this. If I get shot on the street because I'm standing next to someone, and the defense is, no, 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 I was trying to shoot that guy, he's a terrible person, I'd go, well, that has nothing to do with the fact that you
Yeah,
shot me, right? And
right.
right. So in other contexts, it makes sense. The idea that that could be totally left out, is it left out in sentencing? Meaning, when it comes to sentencing, is the fact that he was trying to shoot a suspected child molester, is that a factor? Can that be brought up, and how much can it be brought up?
I think it can be brought up, but I don't think the judge is going to consider it. And I go back to the beginning, and a thought experiment for you and your listeners. You're the judge, okay? You have to weigh two scenarios. Cain Velasquez, A, shot at somebody who was a molester, or B, shot at somebody who was innocent. And which sentence should be assigned for each of those crimes? I think we all agree as people that if he shot at somebody who was a molester, we want the sentence to be way less harsh. But then what if he actually did shoot at somebody who was falsely accused, who lost their business, who got Molotov cocktailed? Is that sentence the same sentence? Of course not. So now the judge is thinking, well, I can't go one way and I can't go the other. I can't assume he's a molester. I can't assume he's innocent. Where am I? So we're going to meet somewhere in the middle. And I think they're more likely than not when I say that they can't assume that he's innocent. They are going to assume he's innocent because he hasn't been convicted, right? That
And
trial
legally, you
didn't move
have to.
forward,
Right.
right? So I think the judge is a person. I think the judge will keep it all into account. But man, we got a preview of the sentencing now, and there's aggravating factors. This guy is the dad's gonna take the stand and say, I can't move my hand anymore. This isn't a flesh wound. This is a lifelong crippling event, which the law takes very seriously. I always joke, I don't joke about, but it's so funny. But in jujitsu, we take chokes. So it's just a joke, right? You get choked, you get choked out, whatever, it's fine. In the eyes of the law, the one aggravating factor that brings a domestic violence from a misdemeanor to a felony is with strangulation. So it's the same thing with aggravating factors of not being able to move your hand anymore. Now we're in serious felony category, serious felony aggravating sentencing, aggravating factors. So it's I saw that article and I said, wow, these people are on the offense. Um, I was hoping that they would be on the defense, right? As a fan of Cain, as a father, you hope that, if he did this, that they said, okay, we did this, let's just, make this go away. Instead they're saying he didn't do it. We have evidence. And not only that, but we're going to put on all this evidence at the sentencing.
If I am your client in a case like this, right? Somebody, I believe molested my daughter. I shoot at him in public. I shoot the wrong guy. We're sitting in an office, you and I, because you would be my attorney. Just letting you know right now that you're the guy I would call.
I'm
What are,
honored.
what are you getting me ready for? Are you getting me ready for, look, anything less than a decade's a win? Because from
Right.
as an outsider, I'm sitting here going, anything less than 10 years, you do good time, you're home in 6, maybe
Right.
5. You know what I mean? So this idea of anything less than a decade is a win, Jimmy. Just get ready to be gone for more than an election.
Right.
Is that what you're telling Kane?
Absolutely. I think that I love to be wrong. I love to give advice and say
It's
like,
good. You're wrong a lot, so it's good.
yeah, yeah, like prove me wrong. I want to
Right.
be wrong.
Yeah.
But from what I've seen, we just have to look at this objectively. We have a gun, we have somebody hit with a gun, with a bullet, and we have the crime taking place in broad daylight. This wasn't like, he was on a busy intersection. He could have shot other people. There's a lot of aggravating factors here, which is why at the beginning I said, listen, 2 decades is definitely possible. 20 years. I would say that anything less than 10 years is a win, because he's facing theoretically life, right? I think it's almost 40
Yep.
years is on the table. I think if he took a no contest plea, they said no actual life. So the problem is you can't just assume that the high end is not possible. it's always there. It's always on the table. So you have to make sure before you accepted this plea that you went through and weighed the cost benefit and said, you know, if we go to trial, we think we're going to get X, and if we take a plea, we think we're going to get Y.
A question I have that is just hard for my listeners and my fans to understand, and it can be hard for me to understand. We see Cain. A judge sees a big, scary professional fighter. The things that
Right.
we see him in a human way, because number one, I've met Cain. I've spoken to him a
Right.
couple times. We see him in a personal way, in a way that
Mm-hmm.
his status as a former UFC heavyweight champion, one of the greatest of all time, elevates him to us. But in the real world, he's a big, scary dude who fought for a living. Is there
Right.
that thing that's hard for fans to understand? Like, no, 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 that thing you know him for that's good can hurt him in the regular trial world that aren't MMA fans. Is that true?
Right. Did you ever bring somebody to watch combat sports that's like from a different generation that just like watches it and sees a knockout and they're just like
They're horrified. Yeah.
horrified?
I'm like, oh, good
We're
left hand. And they're
right. We're
freaking out. I'm
used
like,
to
oh, yeah, I should have
violence.
tapped to that. And his arm folds wrong. I'm like, oh, nice arm
Yeah.
bar. Yeah.
I brought my mom to, I think it was Cain Velasquez versus Bigfoot Silva, and like Bigfoot was like bleeding everywhere, and she was just like, "What are you watching?" And the population is more like my mother than us. It's still not a huge sport. People watch boxing, but MMA. So when they see a highlight reel of Cain knocking out, 7 fighters and doing that to Bigfoot Silva, we look at that and say, wow, one of the greatest of all time. But somebody else could look at that and say, wow, this guy can't be on the street because he does this for a living, which is awful, right? Like he shouldn't be judged by that, because what we do know about him, I've heard beautiful things about him. I've heard that he helps kids in wrestling camp, and he's devoted his life and father, and it's just, you don't want that to be a factor, but again, it's the human element. It's the judge is going to say, I'm not taking all of these things into account. And ethically and legally, they're not supposed to, but will they? I think that the family is going to use his celebrity status against him. I think that they're going to say, we've had to move. Our business has been firebombed.
They've
This
been
person's
threatened
a
a million
celebrity.
times. Yeah, it says
Right.
on the article.
And we've been stalked, and we've had to completely change our life because of an allegation right now. And they can say that. And what if what they're saying is true? What if that is true? I will say this, again, I was playing devil's advocate, but I do think there's a piece of evidence that I caught in the police report that I just want to read to you, which I think it's more likely than not that he will eventually, Golarte will eventually face sentencing. But again, I've read it's only up to 8 years, which is horrifying because it's only one count.
Yeah.
So just looking through the police report.
By the way, Pat always does his research. It's insane. He's like me
Well,
with
it's
fighting about the law.
it's
By the way, I'm just
yeah.
peeling this back a little bit. Pat will send me texts like, dude, I downloaded this PDF file of all the charges against some
Yeah.
jujitsu guy from 20 years ago. And you're like, man, you
Right.
really do dig.
Yeah, well, my thing is like the best part about the law is in most states it's all open. So I don't need to read an opinion about, what they're being charged with. Let me see the charging document. Let me see the police report. Let's make our own opinions as opposed to somebody telling us, hey, this doesn't look good.
Right.
So here's the thing. So Golarte told conflicting information about how he interacted with children at Patty's daycare, the detective said. First, he told police that he had no involvement with children. The suspect then changed his statement that he sometimes wrestled and played with some of the children. The suspect denied any wrongdoing. I think that piece of evidence is actually pretty damning, because what they're saying is when we first confronted this guy, he said, oh, no, I'm never near the kids. Never near them, never near them. Oh, actually, I wrestle with them. Okay. So
Why would you lie about being around kids if you don't have a reason to lie about being around kids?
Right.
It doesn't
Right.
make very much sense. Yeah.
And it's the problem with his case, just very quickly, is there's only one count. So what does that mean to me? That mean, and from what I heard from the allegations in the civil cases, they said this was years of abuse. And if the state is only charging one count, that means that they're only charging one instance. That means that they only believe that they can say, I'm making up a date, but on February 1st at 1 p.m., this happened. They're not saying at February 1st, February 2nd, February 3rd, those would be additional counts. So they're saying we have one shot at this, up to 8 years. And now his defense attorney is saying, well, we have an alibi and video evidence to show that he wasn't there on that one date. So
Doesn't look
that's not
good, but it's one of those things where it's, you talk about domestic violence and all these things. Rarely is it one instance of domestic violence. Usually
right.
it's years. And,
Yes.
one of the highest recidivism rates, I'm sure you know this, is arson. Arsonists tend to do it over and over and over and over and over again. This idea that when it comes to sexual abuse, especially with children,
Yeah.
once they open up the rock, there are a ton of cockroaches
Right.
over there, right? That once you start asking, he did this to every kid there, and you would have dozens and
Right.
dozens of counts, which is why, yeah, 8 years doesn't sound like a lot, but most of these times these people do it multiple times,
Right.
and they get life. We're not seeing that here. And if he
No.
had at a daycare where he had unlimited access to all the children he wanted, the idea that it
Right.
happened once doesn't look good as far as you're, because usually it's 5, 10 counts of
Right.
this. Yeah.
Right. So there's this thing in law that you have to be careful in cases because sometimes the charging document isn't specific enough. So you'll say, oh, like you're charging him with battery, but like what's the date and time? So you file this thing called a bill of particulars saying, I need you to specifically tell me when he committed this crime. And what the state does is say, oh, you want a specific date and time? Here is 18 specific date and times. So it's like if you made me do my homework, I'm going to charge you with 18 counts. So you have to be careful with basically what you ask for sometimes. Sometimes it's better not to know the full extent. And that didn't happen in this case. It's not like they said, here's 18 counts of lewd. I'm not sure what it's called that state. It's something lewd
Lewd
with a
conduct.
child.
Yeah.
Yeah. And it's only up to 8 years. So that says to me that the state is not confident with their case, or they're very confident with one count and not any other instances. They build in their case strongly because they feel like they have this one count.
I remember like somebody like Ted Bundy was only convicted of murder 3 times or something. Because like, well, we only need one, right? It's,
Right.
it's this idea. Yeah, we know he killed 80 women, but we need
Right.
one to stick in Florida, and that's it. He's done.
Right.
So I always found that interesting. Like, yeah, we don't charge him with a serial killer with every murder they committed. We don't have the research.
Right.
We'd be scattershotting, right? Get him one, and that'll be good. In this case, because the maximum is 8 years, one doesn't sound like a whole lot. Doesn't sound like
At
enough.
all.
Yeah.
At all. And that says to me, like, I don't practice there. Are they weak on crime there? And that's just like the sentence for this horrific act, this alleged horrific act. I have to be careful what I say because it's, obviously these
Right.
things aren't completed yet. Or did they charge him with a lesser crime because they felt they couldn't get him with a horrific act crime? I'm sure California has a charge on the books that's some type of life felony for molestation.
Yeah.
Maybe this is a downgraded charge of that because they feel like they can't get him with that. Again, I hope I'm wrong. I hope that this is the first charge. Once he's in prison, they're gonna file, multiple charges with multiple other victims. Sometimes they do things like that where they'll get you in first, they'll convict you, and now they'll say, okay, well, now let's take our time and open up the books and see what else we can find. So maybe that's the case, but I don't know. I mean, you can never, the terrible thing to say, but you can never truly trust what the defense attorney says to the media because, of course, he's going to say, we have an alibi, we have video footage, because his job is to zealously advocate for his client. I don't think he's lying. I don't think that he's making it up, but, he's also attacking the credibility of a 4-year-old. And I saw that he also filed a motion that the judge was sleeping during testimony, which is generally, if you're going to make an allegation that a judge is sleeping in your case, it better be true because if not, that judge is still on your case. So
Kick the hornet's
they're
nest.
doing anything they can to defend Guarte. And like I said, the family case is still pending for the civil case where Cain is suing them. So it's very interesting, and we'll see how it plays out. And I think that we may actually have sentencing. I think it's set for the 20th. So we'll see what happens then.
Well, you'll definitely hear from us after the 20th. Before I let you go, one time for the cheap seats, because it happens every time we discuss this. Explain to the people who say Trump is going to pardon Cain the difference between federal law and state law and what a pardon from the president can cover. Go.
So this is something that you have to understand. The Constitution was created with a series of check and balances. Okay. The president has the power to pardon somebody federally, which means a federal crime. A federal crime is a crime usually in between state lines. So let's say you're a bank robber, you rob a bank in New Mexico, you drive to Nevada, you rob a bank, you drive to California to rob a bank. Okay, now we have a federal bank robbery because you went to different states to commit a series of crimes. If you did something like that, Trump would have the power to pardon you if convicted because it's a federal crime. A state crime, he does not have the power to pardon you for, which is why people say, well, why doesn't he just pardon himself for the New York case? Because that
State
is a
crime.
state crime. I don't want to get into the politics of whether that should have been a state crime, but the bottom line is he does not have the power to pardon Cain Velasquez for this state crime.
Ta-da, love it. So, Defender Donahue, let people know where to find you if they need legal help in South Florida.
Absolutely. So, defenderdonahue.com, Defender D for short. We practice criminal law and car accident law, and I'd love to help. Even if we don't practice in your state, we can usually find a good person for you. So always feel free to reach out, defenderd.com.
Appreciate you, bud. I'll see you in class.
See you in class.
All right, let me finish the recording.